Good morning, everybody, and welcome to this webinar on building safety. I'm Alexandra Pike. I'm a partner in the construction team here at M&R. Just some housekeeping to start with. The slides and a recording will be available afterwards for you. So anything that you missed, you'll be able to catch up on. And hopefully you are all here to hear about building safety. So the Building Safety Act received royal assent in April of this year. And as many of you are aware, it's a huge piece of legislation. It's 240 pages long. So in an hour-long webinar, we can only give you a flavour of the legislation. There are a lot of webinars out there at the moment addressing the Building Safety Act. So to take this in a slightly different direction, we've pulled together experts from across the firm to address key questions arising. And the questions posed are based on the questions you submitted to us beforehand, plus a few of our own. So as I say, I'm chairing the discussion. I'm joined by my colleagues Kate Rushworth, Alison Garrett, Ben Hardiman, Patrick Wishu, and James Horden. Kate is a commercial lawyer with a specialism in construction, and she's advised freeholders on remedial cladding works for the last 4 years. Alison is a senior legal advisor in the construction team, and she's spent some time considering the Act from all perspectives. She's written a number of blogs and articles on the subject. Ben is a partner in our insurance service line, and he specialises in handling construction disputes. He's handled numerous claims involving fire safety issues and allegedly defective cladding. Patrick is a construction dispute specialist, and he's advised construction product manufacturers in respect of the new causes of action under the Building Safety Act. And last but not least, James is a property litigator whose work covers all aspects of real estate litigation. His recent work includes advising a client on remedial work, service charge recovery, and proposed disposals in relation to building safety and cladding issues. These are the areas that we are going to cover today. As we asked for questions beforehand, and we are going to try and cover an awful lot, we're not expecting to have much time for questions live at the end. But if you do have any questions, do please pop them in the comments box with your name and contact details, and we'll be in touch afterwards. Right, so before I hand over to our panel and we deal with the questions, there were just 3 initial points I wanted to make, so just to give you some context. The first one is, as I say, the Building Safety Act received royal assent in April of this year, but much of it didn't immediately come into effect. The government said that much of the Act will be introduced by way of secondary legislation over the next 12 months or so. So while we know what some parts of the Act say and how they're intended to work, in other respects, we don't have the detail of how it will work. And a couple of consultations closed in October, and we're waiting to see the results of those, while others have still being issued. The consultations are very detailed, and it seems likely that the government will keep as closely to them as possible, especially as its aim is for some of the aspects of the consultation to start to take effect from April next year. The second point to make is that the Act looks backwards and forwards. So it looks at what needs to be done and who is responsible to make tall buildings safe to live in, both in terms of cladding as well as other building safety risks. So that includes the spread of fire or structural failure. And this part of the Act is broadly in force. It then looks at what options are available to cover the cost of remedial works done from those deemed to be liable for those defects. And that legislation is mainly in force. And then looking forward, it looks at putting in place procedures for better building safety going forward. And most of that isn't yet in force and is the subject of the consultations. The third point to understand is the different heights and types of buildings. So while the beginnings arise out of the Grenfell tragedy, the Act deals with different types of buildings in different parts of the Act. It's fair to say it concentrates on residential buildings, but some parts of the Act cover any type of building. So far as height is concerned, there are different height requirements for different parts of the Act. So it's worth remembering that Grenfell, which is the block on the left-hand side of the screen, was 24 stories high. The Act talks about higher risk, not high-rise buildings, and they're residential buildings over 18 metres or 7 stories high. So that's the picture top right. other parts of the Act talk about buildings over 11 metres or 5 stories in height, and that's the picture bottom right. So enough from me. Let's get started with question 1. So this is all around qualifying leases. So Kate, perhaps you could start us off. Would you like to explain what the relevance is of a qualifying lease?
Yes, so the relevance of a qualifying lease is that for buildings of 11 metres or higher, it is the key test as to whether the responsibility for funding any cladding remedial works and building safety issues lies with the landlord, or whether there may be some contributions due from many of the tenants. I want to say that this test does purely focus on assigning responsibility between the landlord and the tenant, and it doesn't cut across any other aspects of funding that might be involved, such as any previous developers or anything from the building safety, including where developers have signed up to the developers pledge or where there may be a claim.
See, what are the other building safety risks?
So yeah, that's one of the things that everyone knows about cladding, and that's what you immediately think of when you think of following Grenfell. But there are a number of other building safety issues. Some of it that the Act covers. Some of those are still related to fire, so that might be things like your changing fire alarms, improving sprinklers, dealing with fire stopping and fire doors. But also, as is the case in many parts of the Act, it does go further than just those fire issues. It is also dealing with things that may affect the structural integrity of the building and result in any collapse of the building.
Thank you, that's really helpful. Alison, perhaps I can bring you in. Could you explain what a qualifying lease is?
Yes, there are 5 key points for a qualifying lease. The first one is that the building must have at least 2 dwellings. So a tallish building which only has, say, 3 dwellings in it is still caught. And it must be at least 11 metres or 5 story in height. So Alex, that was your picture bottom right. So it's quite a low level compared with Grenfell. It must be a self-contained building or self-contained part of a building. The leaseholder must have a long lease of a single dwelling, or the leaseholders must have a long lease of a single dwelling. A long lease means more than 21 years, and the leaseholder must have to pay a service charge. And finally, as at Valentine's Day this year, the 14th of February 2022, the dwelling must have been the leaseholder's principal home, or the leaseholder did not own more than 3 dwellings in the UK in total.
Thank you. And what's the effect of a qualifying lease?
Well, firstly, in relation to any cladding defects, the landlord and not the leaseholder pays for the rectification of those defects. It's a blanket requirement. The landlord pays for cladding rectification defects. In respect of building safety risk defects that we've already discussed, so other fire defects, structural defects, then firstly, provided the defect arose in the 30-year period from the 28th June 1992, the landlord has to pay for the rectification of those defects in 2 situations. One, if the landlord was involved in the works which caused the defect, or alternatively, it itself wasn't involved, but it is so associated with an entity that was involved in the works. And in this respect, the Act means by associated, basically a parent company or another group company. So that's the first point, involved in the original works, which caused the defect. The second situation is where the landlord's group net worth is at least the number of affected buildings multiplied by 2 million. So in this situation, the landlord does not have to have been involved in the original works, but if its group worth is more than 2 million times the number of affected buildings that it owns, so if it owns 10 buildings, if its group worth is more than 20 million, then it's got to pay for their building safety risks, the remediation works, and that again, the leaseholder will not have to pay anything. This is radical. It's in the law, we normally cannot go behind the entity that is deemed to be liable for something, but here you see the first indications of looking at group or related companies introduced by the Act. This is the first example of what lawyers call piercing the corporate veil.
Yeah, and that's actually quite unusual. So what happens, Kate, perhaps you could take this one, if neither of those two scenarios apply?
Yeah, so if neither of those two scenarios apply, then putting cladding aside, because as Alison said, that's a blanket, just looking at building safety issues, there may be a contribution sought from the tenants. But whether the landlord can get a contribution from the tenants depends on the value of the relevant leasehold. And there are different caps based on whether the property is in London or elsewhere in the UK. So in London, the cap, in order for any contribution to be sought, the value of the leasehold must be over 325,000. And outside of London, it's 175,000. If the value of the leasehold is below those caps, then again, there's no contribution from the tenant. If the property is above those caps but below 1 million, because there is a slightly different value for 1 million, and I'll talk about those in a second, it doesn't mean that the responsibility suddenly jumps entirely to the tenant or the leaseholder. There is very much quite a bit with the landlord. The Act includes a number of protections to ensure that the amount that can be obtained from leaseholders is still capped at a relatively low amount. So in London, that amount is 15,000, and elsewhere in the UK, it's 10,000. So that still is quite a large amount if a leaseholder suddenly, put forward with a bill for one of those, and the Act recognises that with further protection. So a landlord cannot claim more than 10% in any 1 year. And it is also retrospective to an extent. So whilst leaseholders can't use the Act to go and claim back money that they've already spent from landlords, they can use it to say that they've started to contribute towards those caps. So if in the previous 5 years they have already been paying money into a service charge for those building safety issues, and they can say, well, we've already paid 9,000, so we've only got 1,000 left to go. The other point is that it attaches to the lease and not the leaseholder. So it's not a case that if a leaseholder decides to sell the property that you're restarting that cap again. It very much continues through. So that will obviously be, for those who are looking to sell their property, that will be important information for them to say that, well, we've already paid 5,000, so going forward, the new buyer will only have to pay another 5,000 or 10,000 if in London. So I mentioned that there are some different numbers for over 1 million, and at this stage, the contributions do get quite a bit higher. So with 50,000 for properties between 1 million and 2 million, 100,000 where it's above 2 million. So there is definitely a recognition that the higher the value of the flat, the higher the portion that the leaseholder should be putting in.
Thank you, that's really helpful. So if I take us on now to question 2, Alison, could you explain what landlord certificates are?
Yes, this is linked with what we've just been saying. Landlord certificates have to be provided to leaseholders where the landlord wants to seek to use the service charge for remediation works in respect of the building safety risk defects. They came into force on the 20th of July this year. And as I say, landlords who want to seek a contribution have to issue these certificates. Landlords who are not seeking a contribution, who have deemed themselves liable to pay anyway, do not need to issue landlord certificates under the Act. But we have seen cases, perhaps not unsurprisingly, of leaseholders wanting reassurance in relation to that situation. They want to know for certain that they're not going to have to pay for the remedial works. So that's an area which may need some refinement. I think the key to take away from this at the moment is leaseholders might want reassurance.
Thank you. Yeah, that makes sense. So when do landlords have to issue those certificates?
Well, they have to issue them in 3 distinct situations, and they have to provide them within 4 weeks of the following. These are the 3 situations. 1, being told by a leaseholder that its interest in the property is to be sold. The second situation is where the landlord becomes aware of a defect not notified by a previous certificate, so a new defect that it is looking for a contribution from the service charge for dealing with. And thirdly, on being requested to provide a certificate by a leaseholder, and that's the area that I think we're most likely to see the ground being used for landlord certificates, at least in the short term. I mentioned a little bit ago, Alex, that that landlord has to issue the certificate within 4 weeks. This is a crucial date for the landlord, because if it does not issue the certificate within that 4-week period, and it loses its right to seek a contribution towards the cost of the remediation works.
Yeah, so that's a really important point for landlords to pick up. Kate, do you want to go into leaseholder certificates?
Yep. So leaseholder certificates is sort of the other side of the coin for that. So the landlord certificate is trying to establish information from landlord. The leaseholder certificate is trying to establish information from its leaseholders. So it tries to establish 2 key questions. They relate back to the 5 points that Alison was talking about earlier in terms of what is a qualifying lease. The first question is, what was the position on the 14th of February 2022? Was it the primary residential home? Or if not, was it one of only 3 properties in the UK? And our understanding that this is trying to make sure the qualifying lease is protecting those who are kind of one of a few properties and not someone who is essentially running a commercial, using it commercial rental properties. Whilst this seems a relatively easy question to answer right now, that's because we're only a little while on from 14th of February, and it's likely that you're going to have the same leaseholder answering those questions as was, owning the leasehold in 14th of February. But as we move further away from that, it's going to be harder to establish. So it's definitely something that I think there's going to need to be a bit of a paper trail for this as properties change hands, so that it's easy to understand what was the case on that date. Otherwise, it's just going to be very difficult for leaseholders to answer. The other question that I asked is about seeking to understand where you fall within that cap. So it's what is the value of the leasehold, and the way it asked that is based on what was the value at the last point of sale and what was the date of that sale, and then those numbers can be put into a formula that the Building Safety Act sets out in terms of what that value is today with various inflation and etc., so that you can work out, whether you're in London or not, where you fit under those different thresholds to work out the cap of your potential contributions.
And when might those certificates be required?
So the 2 key scenarios, the first one is, for a landlord, if they're trying to establish, they know they've got some building safety issues to remedy, they're trying to establish who in their building might be contributing towards those and who may not, particularly if it's a building where there's a large number of flats which are being commercial rent, or where you might have some more commercial properties. They'll be wanting to send out a request for all of those, for those properties, to find out who fits into that category, and particularly that question of, if you don't live there, is it how many properties you have? There's no way a landlord can know that without asking the question. In terms of the time frame, it is to some extent at the landlord's discretion how long they give a leaseholder to reply, provided that it's not less than 8 weeks, and that's provided by the Act. It's really important that leaseholders do respond within whatever the period for reply is that the landlord sets out, because otherwise it is assumed that you haven't got a qualifying lease, and therefore there won't be any cap, and you could be responsible for both the cladding remedial works and building safety issues. The other circumstance where it might be, it is about establishing that paper trail, and this isn't something that's required by the Act, but just when I've been advising leaseholders and people buying new properties, obviously they want to know what is the potential value. Are they going to be responsible for cladding risks? And because it does look back at that fixed point of 14th of February, they need to be asking those questions when they're purchasing properties. So I think that's the other scenario when it's very likely to apply. There's obviously no time frame on that, but it'll be part of that transaction.
Thank you. Alison, could you just explain a bit about the form that the certificates need to be in?
Yes, the forms are actually prescribed by the law. On your screen, you will see reference to 2 sets of regulations. They're both quite wordy, but they are slightly different to each other. And the first set of those regulations has at Schedule 1 the prescribed form for a landlord certificate, and you must use that form. It's also important to note that with the landlord certificate, a number of documents have to be attached, including the financial position of the landlord and a lot of information about the work that is to be undertaken. And in that respect, remember I said earlier that the certificate has to be issued within a 4-week period. From a landlord's perspective, there's a lot of work probably to do to get together at least the first few landlord certificates that they have to provide. And so it's not a question of leaving this to week 4 before trying to get the information together. So that's the landlord certificate. The leaseholder certificate is attached at Schedule 1 to the second set of regulations referred to on the slide. As I say, watch out. The titles of these regulations are very similar.
Yeah, it would be easy to get them muddled up, wouldn't it? Thank you for that, both of you. That was very clear. If we move on now to question 3 and remediation orders. Kate, if you're happy to, please could you explain what a remediation order is?
Yep. So far we focused on how do you establish who is responsible for paying for the work, and this turns to actually, okay, well, once you've established who's got to pay for it, how can people make sure that the works actually get done? So a remediation order is something that can be applied for to require the responsible person, assuming likely the landlord, to carry out those works. So it'll be the current landlord for the remediation order. There are a number of different people who can apply for it. First, and perhaps what you would expect, it's anyone with an equitable or a financial interest in the building. So if a leaseholder is concerned that the safety issues aren't being dealt with, they can apply for a remediation order to ensure that that process is sped up. But the Act does allow for other parties who may be having concerns about safety issues to also request to apply for a remediation order, and this includes local councils, fire and rescue services, and also the Secretary of State as well. And we have seen recent examples in the media of the Secretary of State starting to flex its muscles in this way.
Thank you. So what's a remediation contribution order?
So a remediation contribution order, again, another similar name with the Act, which is one of the things you have to keep track of. And this is recognising that it may be the landlord who is the one who is carrying out the works. They might be the one entering into the building contract, but there are a number of parties that are considered to be responsible and are considered to be involved. And a remediation contribution order is a way to get other people involved in a range of individuals. So this can include the original developer, it can include previous landlords. So if you've got a new landlord who wasn't the owner when the works were originally done, then they may be seeking contribution from them, and also other associated companies, which has a slightly different definition than the part of this Act, but essentially largely is those group companies, and it is once again another example of that piercing the corporate veil that Alison was talking about earlier. In terms of who can apply for remediation contribution order, the term in the Act is again an interested party, and that is the same as a remediation order. So that could be again those same leaseholders who are concerned, but it may also be the landlord who's doing the work, so saying, well, I'm doing them, but I want a contribution from elsewhere, sort of opening that up. And again, the Secretary of State, if they feel like or the other outside parties, local councils, they feel like the individual isn't doing it, they can potentially go ahead above and to other parties that they think should be contributing. There are a couple of interesting points from this I gather from speaking from my dispute colleagues. So Patrick, maybe you want to pick those up.
Yeah, thanks, Kate. So there's 2 points that I just want to make really quickly on this, because I know others will talk about them as well. But the first is that kind of piercing the corporate veil point that Alison and Kate have talked about earlier. And in this one, like Kate said, it is a different definition for associated companies than you see elsewhere in the Act. So you do need to look at that all really carefully. The other point that I think is quite interesting with the remediation orders is it is obviously you're remediating some work. So you're looking back at some works that have already been done. And under the Act, those works largely need to have been done within the previous 30 years before the Act came into force. But interesting, there's no, and of course, I'll say this because I'm a disputes lawyer, but there is no limitation period for when that remediation order needs to be sought. So you could see in, like, I'm crystal ball gazing 10 or 15 years down the line, but you could see somebody trying to bring a claim under or seeking these remedial works to be done at that point in time, because there is no time limit within which you need to have done it. It just goes 30 years back from when it came into force.
Thank you. That's interesting. Again, with a disputes lawyer hat on, I would find it interesting. While you are speaking, could I ask you to look at the causes of action and changes to limitation, Patrick? So
yeah, of course.
do you want to start by explaining the new causes of action under the Act?
Yeah, so there's 3 new causes of action that have been brought into force under the Act. There's one more that we expect to be brought in, but it hasn't yet. It's been on the statute books for nearly 40 years already, though, so it might be a little while before it does actually show up. So looking at those 3, we have one that's effectively an expansion of the pre-existing cause of action under Section 1 of the Defective Premises Act 1972, and then there's 2 new ones that are in respect of product manufacturers. So there's a construction product manufacturers / suppliers cause of action, and one against cladding product manufacturers and suppliers as well. So they're all a bit disparate, but one easy way I find to try to understand them is to look at the common threads that run between all 3 of those. So one, like Alex, you were talking earlier about the heights of the buildings that this applies to. These apply to relevant buildings of any height. And that means either a dwelling or a building consisting of 2 or more dwellings. And then the second one is that for all of these causes of action, there needs to have been, it needs to have rendered, the relevant works need to have rendered the relevant building, the dwelling, unfit for habitation at the time that the works were completed. Unhelpfully, the Act doesn't say what fitness for habitation is, but it is at least something that is in Section 1 of the DPA and is talked about in the case law that relates to that. So if we start looking at that just quickly, it'll kind of put everything else into context. So the pre-existing claim under the DPA was a statutory duty put onto contractors, subcontractors, anybody carrying out works in relation to the provision of a dwelling. So it's important that it's a provision of a dwelling, so it only applies to new builds. So, or arguably, if you're converting something into a dwelling, but not just doing some works to it. And what they need to do under that statutory obligation is to carry out those works in a workmanlike or professional manner and using proper materials such that at the time of completion, the building is fit for habitation. Again, the DPA doesn't say what that means. So you look at the case law, that at least has been enforced for nearly 50 years. So there are a number of cases on it. And kind of a helpful short summary of what that is that the dwelling needs to be capable of occupation for a reasonable time without risk to the occupant's health or safety and without undue inconvenience or discomfort to them. So it's broader than these building safety issues and building safety risks that you see under the Act, which is in respect of fire and structural issues. It can include things of a lower threshold, right? So it can even just be an inconvenience or causing discomfort. So some examples that we've seen in case law is the frequent breakdown of a lift in a high-rise block of flats, the lack of a damp-proof course in a house, or inadequate foundations.
Thank you. How are the new causes of action different to the ones in the existing DPA?
Yeah, so the first one, Alex, is the kind of extension of that DPA claim. So that's a new Section 2A of the DPA brought in by the Building Safety Act. And it is largely the same as what's under this Section 1 cause of action, but it applies to any works carried out in relation to a dwelling. So it's not just a new build, it's kind of renovation works and things like that. But it does need to be done in the course of a business. So any DIYers who are carrying out kind of remedial works to their house are unlikely to be caught by that. The other 2 causes of action are quite different. So there's the cause of action in respect of construction products. These are a bit oddly expressed, I think. So these are the ones that you may have seen. We've done a series of blogs on them. So I'd say take a look at those. I won't talk about them exhaustively, but they are the kind of conditions A to conditions D that need to be met. The kind of key act that triggers these causes of action is the Condition A Act, which is something done by a construction product manufacturer or supplier, which is either, I think the first one is breaching construction product regulations. The second is kind of a misstatement or misselling of that product. And then the third is manufacturing an inherently defective product. So that Condition A Act for the construction product cause of action is prospective only, so that act needs to have been done on or after the 28th of June 2022, and it needs to have caused, once that product is installed or brought in and built into a dwelling, to have caused that dwelling. It doesn't need to be the only cause, though. It can be a cause of the dwelling being unfit for habitation. So again, you go back to that test under the section 1 of the DPA. The cladding product claims, though, it's still very similar to that. It is conditions A to conditions D, but it is retrospective only in respect of the Condition A Act. So that needs to have been done before the 28th of June 2022, and it only applies to cladding products. And so a cladding product is defined under the Act as a cladding system or a component of a cladding system, and it needs to have been installed into the external wall of a dwelling or a relevant building. And there is some guidance in the Act on what an external wall means, and in particular, if you're looking at something with a pitched roof. Unlike the construction products claim, though, that Condition A Act has to have, like I said, happened before the 28th of June 2022. In that regard, it's retrospective. But the installation works and the works that kind of cause the cause of action to accrue can happen after the 28th of June. So you do have two ways of looking at those claims. The point that's really interesting about this new cause of action, though, for cladding products is that it's that retrospective nature of it. So what it does is essentially say that for the last 30 years, there's been this cause of action on the statute books. So even then, even though you couldn't have contemplated that what you're doing was a wrongful act in this regard, you can still have a cause of action brought against you. So it does look back really quite a long way. And because it looks back so far, the Act also introduces a rather interesting but completely untested exemption, whereby if bringing that claim against a defendant would breach their human rights. And so that would probably be a breach of Article 6, being a right to a fair trial. But like I said, that's completely untested, but it's probably something that we're going to be seeing quite a lot of argument around.
So you mentioned a 30-year limitation period for one of the new causes of action. So how else do the limitation periods work under the Building Safety Act?
Yeah, so that 30-year limitation point, so that's for the cladding product claims. There's also a very similar thing introduced in respect of the pre-existing Section 1 of the DPA Act. So again, that one is now treated, that cause of action at least has always been there, so people knew about it, but it used to have a limitation period of 6 years. It now has a limitation period of 30 years, and that's retrospective only. So you're looking at potentially being able to bring claims going back to the 28th of June 1992, but you have to do that really quite swiftly because that 30-year clock is ticking. The Act has introduced kind of a grace period for those really old claims. So if the building was completed between the 28th of June 1992 and probably the 27th of June 1993, you have to bring the claim by 28th of June 2023. So you now have about 6 months left to bring those claims. It also, because it goes back so far retrospectively, it also has that human rights exemption. But there is also a point that needs to be borne in mind, that this retrospective effect of Section 1 of the DPA doesn't resurrect claims. So if you've already settled a claim between the parties, or it's already been the subject of a judgment or an arbitral award, it's gone. You might be able to consider whether or not you could bring a claim against somebody else who's carried out works in respect to that building, but each one of these will have to be considered on its face. That's that 30-year point on that retrospective only. There is also this for prospective causes of action, it's 15 years now. So that we're all kind of used to as lawyers seeing 6-year limitation period for something done by simple contract, 12 years for a deed, and in some cases up to 15 years for a tortious claim. But now for these new causes of action, so the new Section 2A of the DPA, the the construction product cause of action, and those bits of the cladding product claim whereby the Condition A Act was done before the 28th of June 2022, but the installation's completed afterwards, you have 15 years to bring those causes of action. That 15-year period also will apply to that fourth cause of action that hasn't yet been brought into force, and that's Section 38 of the Building Act, which is, very briefly, it's a civil claim for breach of building regulations.
Thank you. Yeah, there's a lot to get your head around there. Are there any other points you want to mention before we move on?
The only point, just for any construction professionals on the webinar today, is that for these new causes of action, you can't contract out of them. So I know that's something you might want to be trying to think about, but the Act is very clear that you can't for any of these.
Brilliant. Thank you, Patrick. So we'll move on now to question 5, which is on building liability orders. Ben, perhaps you can take this one for us and explain what a building liability order is.
Sure. Thanks. Morning, everyone. Well, if you thought that the significant and retrospective changes to limitation periods that Patrick's just talked about were groundbreaking, a building liability order, or BLO, is bordering on revolutionary. It touches on what Kate mentioned earlier. It's the introduction of a new scheme where liability for construction work can be extended beyond the entity involved in the original build and through to its associated entities. Now, those entities may have had will have had no involvement in the work complained of. They may not have even existed at the time that work was done. So it touches on what Kate and Alison were talking about. This is a scheme which intentionally allows the corporate veil to be pierced, and that is a really significant change to what's been more than a century's worth of corporate and contractual law that we've all been used to. Why is that revolutionary change necessary or considered to be necessary? Well, according to parliamentary debates and then subsequent government guidance, the fundamental purpose of this provision was to address a concern that developers and contractors were setting up special purpose vehicles, or SPVs, sometimes offshore, and they would then act as the developer responsible for the build before being wound down, perhaps once the work's completed and once the money made in the project has been dissipated into the corporate structure. Now, until now, privity of contract would shield that corporate group that sits behind it from any liability for problems which may subsequently arise.
I see. Yeah, that's a significant step. I can see different parties with different interests will see pluses and minuses to that. Can you outline how it operates and why it's relevant?
Yeah, its relevance is actually not all that dissimilar to the remediation orders and remediation contributions that Alison and Kate spoke about earlier. And its intention is to give a route through to money, but there are two critical differences. Firstly, there needs to be a relevant liability, and that is defined as being a liability under the Defective Premises Act, Section 38 of the Building Act when that comes into force, or as a result of a building safety risk. And that is, the building safety risk is defined as the risk to the safety of people in or around the building arising from the spread of fire or structural failure. The second key difference is the way in which that relevant liability may be established. Here, building height is irrelevant. And indeed, I think really this is not limited to fire safety because of the Defective Premises Act rights. It does not need to be a fire-related issue. What isn't 100% clear is whether some form of judgment is necessary to establish the relevant liability, or whether you can go straight for the BLO. It appears to be that a judgment must first be obtained before steps can be taken. And for those heavily involved in construction, you will have adjudication on your mind. Again, the Act is not clear, but given the lack of finality in an adjudicator's award, having discussed this and thrown it around the panel beforehand, our view is really that a BLO is probably not a route to obtaining payment pursuant to an adjudicator's award.
Thanks, Ben. And who can apply for a building liability order?
Anyone who can establish that relevant liability. So the purpose of the Building Safety Act is to give rights to parties who may previously have faced a challenging route to establish liability. So that's why there's access to the remedy via the DPA and the Building Act when it's in force, and also for the extension to the limitation periods Patrick spoke about earlier. One point to note is the concept of a building safety risk does not of itself give a potential claimant a cause of action in their own right. On the face of it, I think, therefore, this is a remedy that's probably going to be most likely to be enforced by parties who have been a claimant in a way, so pursuing direct contractual rights or perhaps under the DPA, and that will be a process via the courts.
And could you quickly run us through the application process?
Yeah, sure. So this is really defined by section 131 of the Act, and that explains the route to being able to pierce the corporate veil. So once the parties got their relevant liability, and assuming it hasn't been paid, an application could be made to the High Court to enforce that liability, and that will be against any party who is associated with that original party. Now, the concept of association is explained in the Act. It's all about control. There are examples set out in section 131. In summary, it is all about the ability to acquire the value of that original entity. So perhaps taking 50% of the share capital or more, 50% of income or more, the ability to exercise more than half the votes in a general meeting. And I think really the point to have in mind for this is that lawmakers are giving the courts the power to follow the money through the corporate structure. Just to say as well, information about corporate structures and the rights that I've just talked about can obviously be very difficult to establish, particularly for parties offshore. Section 132 of the Act provides a mechanism for information to be obtained via an order of the High Court. It's an information order requiring the target company to provide information relates to that association test.
Yeah, it's all quite new, isn't it? Are there any
Absolutely.
complications or other defences that we need to bear in mind?
Yeah, so this is obviously a fairly draconian step, and so let's assume that an applicant can overcome those various hurdles around liability, association control, etc. This does remain a discretionary remedy. The court can only grant the BLO if it's considered to be just and equitable to do so. Now, we don't have guidance within the Act about what is meant by that phrase. There is some case law out there. There's some other statutes that use it as well. But we're really very early days here. We're 6 months in. It's not something that's been tested by the courts yet. So this is really an area to watch this space.
Thank you. Yeah, really new, and it will be really interesting how it develops. Going to move on now to insurance, and anyone who's had any involvement in dealing with buildings where there are fire safety concerns will know that the rectification is expensive. So before parties pursue claims, they'll want to have a reasonable idea that the target is going to be good for the money. Ben, you specialise in advising on insurance aspects. Are there any issues you need to talk us through?
Yeah, let's look at this through the lens of a professional indemnity policy, because that's the most likely or most relevant policy that's likely to be considered in this sort of fire safety environment. I don't want to teach anyone on the call who knows about insurance to suck eggs, but I think the important thing is that a PI policy is claims made. That means that the policy which responds to a claim when a claim is made is the claim that is the policy that exists at the time the claim is made, not when the building was built. So this is relevant because a developer or perhaps a funder who may have obtained copies of insurance cover notes or details from brokers when contracts were agreed about the policies in place are not going to be up to date or not going to be relevant by the time the claim occurs some years later. Now, in terms of retrospective extensions to limitation provisions that Patrick spoke about, the insurance industry is au fait with claims dating back many years. I mean, as Patrick said, we have claims under deed dating back 12 years. Tort potentially goes to 15 years, and potentially other limitation periods allow claims to go even further. 30 years, though, is something of an outlier, and what you may see is insurers starting to insert what's known as a retroactive date into policies, which means a policy only responds to claims made after a certain date, so irrespective of when that claim is notified. Now, whether that will occur really very much depends on how the insurance market and the construction sector reacts to these changes. I doubt there'll be a one-size-fits-all stance, but it is an option.
Yeah, and that could really limit the effect of some of these changes potentially. Are there any other issues associated with insurance to be aware of?
Yes, well, anyone who has been involved in claims or insurance since Grenfell will be aware that the PI insurance market has become a far more challenging place to obtain cover. Cover has become more expensive and more restrictive. It isn't just Grenfell, but that was certainly a contributing factor. And so the vast majority of companies operating in the construction sector who hold PI insurance are very likely to have significant restrictions and exclusions relating to claims arising from fire safety. Now, I think in effect, for a claim made today and going forward, most entities are probably unlikely to be insured for a claim of that nature, or certainly it will be restricted in value.
And how will it work with BLOs? I mean, they're obviously, as you say, revolutionary. So how will the PI policies respond?
Yeah, well, this is something that obviously hasn't necessarily been tested yet. But I think the position is probably that a PI policy generally only responds to claims arising from the entity who carries out the professional service. Now, the whole concept of a BLO is that the applicant is looking to go beyond that entity and to secure payment from other entities who did not carry out that professional service. So each case will be looked at and its own merits. It will very much depend on the words of the policy. So there will be outliers, I'm sure, but in general, I don't think an insurance policy is likely to respond to a BLO, Alex.
Thank you. So we'll move on now to some of the legislation that we're expecting to come in over 2023, starting with the golden thread. And James, perhaps I can bring you in now. Would you be able to explain what the golden thread is?
Yeah, one of the historic problems I think that have been encountered is that when you're dealing with a building some years after it's been constructed, is that the owners of the building at that time no longer have access to the design and construction material to tell them how the building was built, how safety was designed into it, and so on. And therefore, it's very hard to deal with some building safety issues as they arise. So the legislation introduces the idea of the golden thread for higher risk buildings. And this is basically a shorthand term to describe all the relevant documentation that relates to design, construction, building safety, not only during the design and construction process, but throughout the lifetime of the building. And this is going to be available not only to the regulator, but obviously also to the building owner who's responsible for building safety, and also no doubt to the leaseholders who might be concerned about particular issues with their building. So it's a catch-all phrase to describe safety documentation that has to be maintained throughout the lifetime of the building and during its initiation process. And conceptually, it's quite closely linked to these ideas of gateways that I think, Alison, you've got a couple of comments on.
Yes, I wanted just to mention what gateways are. As James said, it applies to what are known as higher risk buildings. That's buildings that are over 18 metres or 7 stories in height, which have 2 or more residential units. And the gateways apply during the design and construction phase of a higher risk building. And it is probable that in terms of those buildings, for the design and construction phase alone, we're going to be talking about care homes and hospitals as well. The government is consulting on this at the moment, but hasn't made a decision. So there are 3 gateways that you need to know about. Gateway 1, which is known as the planning gateway, it's been in force for over a year or so now, and it's relatively straightforward. Gateways 2 and 3 are not yet in effect and are much more complicated, especially if you're the person building the building. Gateway 2 is building control approval stage, and at this point, I think it's important to make the point that for all higher risk buildings, it is intended that the building control authority, for which there will be no choice, will be the building safety regulator.
And who's the building safety regulator?
Well, it's a new role, and to a large extent, it will only apply to higher risk buildings. it is part of the Health and Safety Executive, and it's going to have some really draconian powers. It's going to, in relation to Gateway 2, this is not just going to apply to a new build high risk building, but it's going to also be looking at other buildings that are linked with high risk buildings. Some of those that might surprise you are that it will be the Building Control Authority if you have a building where there's going to be a material change of use, so that an out of scope building becomes in scope. So for instance, if you have an office block that's being converted to a residential block, that will, the Building Safety Regulator will be responsible, the Building Control Authority, for that. And perhaps even more surprisingly, if work is being undertaken to a higher risk building so that it will no longer be a high risk building. So for instance, if you've got 2 residential units and you're turning them into shops, the Building Safety Regulator will still be the building control approver for those types of works as well.
Yeah, that does sound unusual. Wouldn't have expected that. How will the building control approval stage work?
Well, as a warning, lots of information is going to be required. I'm not going to go into the detail. I'll just give you some snippets. You'll need contact information, obviously. You'll need a description of any existing building, if there's any. You'll need the proposed building works to be included. There'll need to be a plan, and there'll need to be what are called prescribed documents. These will include a competence declaration, i.e. that the person asking for the building to be built is satisfied that the principal designer and principal contractor, and here we've got individuals that are more commonly thought of in relation to the CDM regulations, but without going into too much detail, they are going to have greater duties under these sorts of buildings and buildings generally in relation to safety. The person building the building has to provide a competence declaration that they're satisfied that both of those are competent. There will need to be a planning statement. There will need to be a design and build approach document, a fire and emergency fire, a construction control plan, a change control plan, and a mandatory occurrence reporting framework. And they'll also, if you're dealing with a partial completion or a sectional completion, a partial completion strategy. I could go on, but that probably gives our audience enough of a feel about just how much information is going to need to be provided at this stage. I think I should also mention that the regulator will have 12 weeks, or it's intended they'll have 12 weeks to determine an application. That's quite a long time, and that's assuming that they approve it on first bite, so to speak. So I think programs for building works are going to need to bear that in mind and take that into account. And then the sting in the tail of this is that you cannot start work without approval. It is irrelevant whether you've got planning permission or not, you cannot start work without approval. And if you do, it's an offence, and you could be subject to 2 years in prison or an unlimited fine. It's referred to as the hard stop.
Yeah, that sounds quite challenging. What about Gateway 3?
Right, Gateway 3 is meant to take place at completion, and you must apply for a completion certificate and possibly also a completion notice. That's been out for consultation, and we're waiting for confirmation of that at the moment. Again, the applicant will need to supply a lot of documents, including a compliance statement confirming compliance with building regulations, and a golden thread statement, which leads me back to what James was talking about, and that will confirm that the golden thread information has been provided to the relevant person. That will be an accountable person, and we'll talk about that, what an accountable person is, a little bit more in a moment. And there'll also need to be a competence declaration, and that will need to be signed by the client, the principal designer, and the principal contractor. The regulator will have undertaken inspection during the course of the works, and they will also need to undertake a further inspection before they provide a completion certificate. They issue a completion certificate. Again, we're being told it could take up to 12 weeks for the regulator to decide whether to issue a completion certificate. So again, that needs to be taken into account in any building project. There can be no occupation of a higher risk building without that completion certificate. Again, criminal offence, 2 years in prison, unlimited fine.
Yeah, so that's going to have a huge impact on timings for occupation of new buildings. You mentioned the accountable person. So if we come on to that quickly now, that's our last question this morning. James, do you want to start us off with who an accountable person is?
Yeah, sure. I mean, if you think about the ownership structure of a block of flats, the most basic way in which a block of flats is owned is you have a freeholder who owns the building, and then you have the individual leaseholders who have leases of their individual flats. Those individual flat leases will include the interior of the walls. They won't include any structural elements. They might include non-structural walls. They won't include structural parts of the flat itself. Obviously, apart from the flats, there are going to be some common areas. There'll be entrance halls, stairwells, passageways. There might be a car park, who knows. So that's a basic starting point for the way in which a block of flats might be owned. There might be slightly more complicated structures where you have intermediate leaseholders between the freeholder and the flat owners. There might be a management company which either has repairing obligations for the common parts or might in some cases have its own lease of the common parts. So the Act introduces the concept of an accountable person. It has a core definition, which is that an accountable person is a person with an interest in possession in the structure and exterior of the building. And it's also potentially somebody who has a repairing responsibility for any of the common parts. Common parts includes the structure and exterior. So in some situations where you have a management company or multiple leaseholders, you might well find out that there are more than one accountable person. It might well be the case, for instance, that the freeholder retains the structure and exterior, but there's a management company which is responsible for maintaining the common parts. In that case, you're going to have two accountable people. So having got to that situation, the Act introduces the idea of a principal accountable person, and that's the person who's mainly going to be responsible for building safety duties during the lifetime of a building and during its occupation. And the principal accountable person is basically the person who is responsible for repairing and maintaining the structure and exterior of the building. That might be the freeholder, but it might also be a long leaseholder. Sometimes you might have a freeholder who's let out the structure and exterior of the whole building on a 900-year lease, say, and then it's going to be that person because they're the person who's fundamentally responsible for maintaining the building.
Alison, could you explain a bit about their duties?
Yes, I think the key duty, which has to be undertaken by the principal accountable person, is that they must register the building before occupation with the regulator.
And when will the requirement to register apply?
Well, the legislation is not yet in force, but it is anticipated, according to the Health and Safety Executive, that for existing buildings, i.e. those buildings that already have people in occupation, registration will start in April 2023 and will need to have been undertaken by October 2023. So relatively quickly.
And what happens if you don't register?
Well, just before I mentioned, for new buildings, the registration is going to be October 2023. If you don't register, my comment as before, it's an offence, 2 years in prison, unlimited fine.
Fantastic. I'm sure people are really glad to hear that. Finally, are there any other obligations?
Yeah, there are loads of obligations. The principal accountable person and all other accountable persons will need to maintain a golden thread. They will need to keep key building information. They will need to provide a building assessment certificate to the regulator. They must put in place a building safety case regime. They must provide safety case reports. They must have a mandatory occurrence reporting system, and they must liaise with residents, including providing a residents engagement strategy. And it's going to take a huge amount of organisation. It's going to take time, and it's going to take money to comply with this.
Thank you, Alison. Yeah, there's a lot to think about. Thank you to all of our speakers. And thank you to all of you for attending. We've included as an aid memoir the key dates, so that's includes some of the ones that have already happened and some coming up in the future. And as I mentioned at the beginning, the slides will be sent to you, so you'll have a copy to review. And would be grateful if you could fill in the short feedback form, which will pop up when you exit the webinar. Thank you very much for attending.